Yeah, listen. They're talking about giving me 4 to 6 years. We're going to sell the house and I'm not coming home. Okay? It's only for the YouTube channel. Sergeant? So all I did was tell the truth. So... you understand? This isn't any more about YouTube or me or Metro State. It's about people getting retribution for the past.
But that wasn't me.
Afternoon, Your Honor.
Good afternoon. Let's go ahead and call both cases on the record.
State of Florida versus Jeremy Charles Dewitte, 2020 CF 4466, 2019 CF 12733. State.
ASA Crew for the state.
Amir Ladan on behalf of Mr. DeWitt, Your Honor.
Let's go ahead and swear Mr. DeWitt in.
Raise your right hand. Do you solemnly swear that the testimony you shall give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may be seated, sir. Sir, tell me your name and your date of birth.
Jeremy Charles Dewitte, Your Honor, 21080.
Mr. DeWitt, on these two cases, you previously... Mr. Sinclair.
Sorry.
In these two cases, you previously entered pleas. You were sentenced to, on a departure sentence, to a period of time in the Department of Corrections followed by a period of time on supervision. It's now been alleged that you violated your supervision. Was it straight probation or was it community control on the front end?
It was probation with a GPS monitor that I don't believe was through the state, but nonetheless monitored by probation for that purpose.
And also curfew and quite a few other times.
So procedurally, there was an initial affidavit of violation filed. I signed the warrants in each case. I set bond at none. Subsequently, Mr. Ladan, you filed a motion to set bond on the VOPs prior to them being executed. I declined to grant that motion.
Actually, Judge, I hate to interrupt you. I filed a motion asking Your Honor to consider recalling the warrant and allowing for a summons, which you declined on, at which point then I filed a motion to set bond.
Were you aware, Mr. Ladan, that amended affidavits of violation had been filed?
I became aware of it today.
All right. In the amended affidavits of violation, they've alleged additional violations, but more importantly, they've identified the defendant as a violent felony offender of special concern.
Right.
I believe pursuant to the Anti-Murder Act, I'm not allowed to release anyone who qualifies as a violent felony offender of special concern prior to the determination of whether they willfully violated probation or not.
I believe Your Honor has the authority to hold a danger hearing to make that determination.
If you go back and read the statute, it says upon an adjudication, in other words, once you've determined a violation has taken place, you must conduct a danger hearing before proceeding to sentencing. Earlier in the statute, it actually says that unless it's a like financial obligations,
right.
If it's any other basis violation, they shall not be released. I actually conducted a couple of danger hearings as part of bond hearings before I went back because the lawyers convinced me, oh yeah, we do this all the time. You just do a danger hearing.
Right.
Then I went back, reread the statute, and much to my chagrin, I felt like the lawyers hadn't accurately stated the law. So I don't believe I have any authority to grant release because it's not a situation where they're alleging only financial obligations. You look like you don't want to accept my representation on that.
No, it's not that. I want to look up how probation can make the determination that he's a violent felony offender of special concern without presenting evidence to the court such that it would preclude me from having Your Honor consider this. So it's not that I don't accept your representation. I want to make sure that procedurally I'm not getting the cart before the horse of my client.
Yeah. Well, so one thing I find that people oftentimes miss, you can be found to be a violent felony offender of special concern because, A, the offense that you're on supervision for is a qualifying offense.
Sure.
You can also be found to be a violent felony offender of special concern if you have previously been convicted of a qualifying offense and you're now on probation. Looking at his score sheet, that at the time he entered his plea,
I don't bring that with me.
I suspect a couple of those offenses are qualifiers. There was a prior for a lewd or lascivious battery, which I believe would be an enumerated offense. And then he pled to, the score sheet says he pled to an aggravated assault with a deadly weapon, which I believe would also be a qualifying offense.
Your Honor is correct. I know that prior offenses are considered for that designation, and it's not simply what are you being supervised for. I accept that that's 100% accurate. I don't remember having Mr. Dewitte plead to an ag assault deadly weapon, and I've handled the lion's share of his case.
I'm just looking at the score sheet that was submitted to the court
Right.
at the time of sentencing, and it lists an additional offense of aggravated assault with a deadly weapon.
I see that it's listed under 2020 CF 2415.
I did print off the plea agreement form.
No, you're right. That's my handwriting. Thank you. So going back to my original comment then, Judge, the court has to make a finding simply based on that representation in the VOP affidavit, or is there an opportunity for the court to make an assessment as to whether that's applicable or
Well,
not?
I think if somebody came before the court and said, Judge, I have no idea why they did this. My person was on probation for possession of cocaine, and it was their first offense. So I can't see anywhere how they could possibly come up with that conclusion. Sure. I think the court could intervene and say there's on its face nothing that would suggest that. But I think once there appears to be something that would suggest he is on supervision for a qualifying offense, or he has a prior for a qualifying offense,
Okay.
I think that's sufficient. I don't think it's appropriate for me to go any further.
So understanding the court's position, and I'm not going to be able to present anything that's going to be all that persuasive to change that, then what opportunity might there be for us to engage in some plea conversations about resolving this? Because the crux of where I find myself is this. I haven't presented it in the motion directly, but we began what we had hoped to be a process to short-tail this about November 4th to 7th, in that window of time when I was retained by my client to try to modify or file a motion for the court to consider modifying or amending the requirement that he remove this YouTube channel. And the crux of our position, Judge, is that he has attempted to remove it, but that some time ago the password and setup of all of that was taken over by another individual and has kind of interfered with his ability to effectuate that obligation. So be that as it may, and I can present whatever the court and the state feels is necessary to affirm that my client has made proactive efforts to do that. I was retained to try to file a motion to modify, and the thought process was either to get an order from Your Honor directing YouTube to shut this down at the court's direction, or doing something to allow us to facilitate that. Because that's what began this dialogue, was he had 60 days from the date of his release from DOC to facilitate it, and he can't do it. He told his PO he can't do it. He's not trying not to do it. So
Wait a minute.
And I'll tell you right now, you posting stuff over the next few days will fuck them all up. Because they're thinking that it's going to stop. They don't realize that you're about to put these shit out there, and how I just made fun of them and kept talking shit to them. You think you're going to post other gun videos out there? Dude, it's going to blow their mind because they think I can't do it right now.
Anyways. That's what I said.
is there a mechanism that we could still get from A to B and get him back out on supervision so that we can continue forward with the case? I mean, I hate to have him admit to something that is defensible, but at the end of the day, I think the net effect is the same thing, and I'm trying to be a pragmatist. I think we're in the same position. So would that be something that the court would entertain today?
It's not, Mr. Ledan, and just, again, I like for people to leave the courtroom with a fair sense of where things stand with me. The challenges I see at this point is your client negotiated a fairly favorable resolution in regards to a number of counts being dismissed and, more importantly, a departure sentence in a situation where, I want to misspeak now. So the fundamental problem is he got a departure sentence in theory because he's going to do all these things that he agreed to do at the time of the plea. I don't want to get into what his defenses might or might not be at a hearing. And I don't even want to prospectively address that. If he's found in violation, my starting point is, what is his guideline sentence at this point in time? In addition, he's got, if his score sheet that he pled to is correct, he's got prior falsely personating officer convictions. He's got prior violations of probation, prior violation of community control, using false or fictitious name in a driver's license application. He's got the lewd or lascivious battery. I understand him from 2005, but he appears to have an extensive prior criminal history. And, Mr. Ledan, I'm sure you're well aware, in this courtroom, when I'm presented with defendants who commit the same crime over and over again, I begin to form the conclusion that they don't care that that is conduct that is criminal in nature. They're just going to do what they want to do. It's everybody else's problem. And when a defendant convinces this court that that is their attitude, I think the only thing I can do with them is put them somewhere where they can't flagrantly thumb their nose at the law. So that's the starting point of his problems, why I'm not inclined to tell you that, sure, we can work this thing out, get him back out in the community. I'm not saying at the end of a sentencing presentation, if he's found in violation or if he decides to admit, that you won't be able to construct and present a case that would be persuasive to the court. But I just want him and you to understand he's pushing the rock uphill at this point in time. He entered his plea, was supposed to go to prison for
about 6 years.
A lowest permissible of 68.18.
Right.
Got substantially less than, I think, was it 20 months?
Not quite. Right.
18?
Right.
And now he's violated, and now there's allegations on top of this issue with the YouTube channel that there have been other violations. So,
to be fair, the other violations were while we were pending what I was trying to do with the court. So I think there's some mitigation that might be of value to the court's consideration on that front. And I think that I always appreciate the court's candor because I think it's important for the litigants to understand where things stand. I get that maybe we're not in a position to resolve it today, but I thought it's worth the inquiry. But what I would say is at the time that this deal was accepted, there was a reason that it was accepted, and not the least of which was the nature of what the state was doing in exchange for the plea being accepted on their end. And so this being a technical violation and not a new law offense alleging that he's thumbing the nose at anybody, and in fact has a viable defense to the inability to facilitate it, I think that once the dust settles, Your Honor might have a much different perspective. But I do value you explaining to the defendant and myself kind of what your overview of that is and why we can't get it resolved today. So where does that leave us from a scheduling standpoint, Your Honor?
I assume you want to enter a denial at this point. I'm not sure he's formally been arraigned.
Yes, Your Honor, we'd enter a denial at this point.
And he is not, Your Honor.
He's scheduled for in-jail arraignment on 12/12.
We'll just do the arraignment now. We'll enter a denial on the admitted affidavit of violation in each case. I'll put him on my Monday, January 23rd, 2023 VOP status date, and my Thursday, January 26th, 2023 hearing date. If y'all tell me on the 23rd you're ready to go to hearing, or you can set it for entry of admission before that. And my schedule's a little bit tight this December because I'm going to pick up emergency duty starting on Friday the 16th.
Right.
And the challenge that caused me, that's usually a full day's.
Here or there?
No, I'll be doing it on the weekdays. I'll be here. The challenge is I can spend all day at my computer knocking out warrants. So what I've learned is I typically don't set long substantive things. Negotiated pleas, I can do. Quick bond hearings, I can do. 2-hour, child hearsay motions or motion suppress. I just don't do those when we got emergency duties. It's not fair to litigants.
Sure.
For me to be constantly wondering, has that homicide warrant arrived yet? So it's just the reality, at least from my point of view, when you're on emergency duty, that's your full-time job for the week that you have duty. If I don't go to trial on December 12th, then I'll have plenty of time.
Yes, Your Honor.
Right now, I've got
None.
18 or 19 cases claiming they're going to go to trial. I'll sort that out on Thursday. So
For the purposes of the 23rd, Your Honor, what time is that hearing?
I set them all at 9 a.m. and I just address the lawyers as they come in. We don't transport defendants for VOP status day unless the defense has specifically contacted my JA and said it's going to be a resolution. Can we bring the guy over or the gal over and
I'm making a
resolve the
note of that
case?
for myself. I'm listening. I just want to make sure I'm sending that to my office so that they're aware of how it's going to flow. So, and the 126 hearing date, is that also a cattle call at 9 a.m., Your Honor?
So I've done one VOP hearing since I've been back downtown.
Okay.
I managed to split it across 2 different days. Maybe I've done a second.
You did one with me.
Yours was split across 2 days.
That's
I'm not
correct.
sure that's something I'd brag about at this point.
Personally, in the almost year that I've been here, have not seen a VOP hearing.
Okay. Well, we're efficient at getting stuff done. I like it.
So, might be a first for me, but.
So, Mr. Dewitte, I'm talking to your lawyer. He represents you. It's his job to speak on your behalf so that you don't say something in this courtroom that he can't undo later on. When I send you back to the Orange County Jail, you can talk to your lawyer to your heart's content. But you're not going to address the court while your lawyer's standing here in the courtroom, okay? Okay. Anything else you need to do on Mr. DeWitte's case this afternoon?
Yes, Your Honor. May we approach?
So, Dan, you want to come up?
Sure.
Can I hold on to this or do you need that?
Do y'all want to be on or off the record?
Off the record.
So, Dan, are you comfortable off the record?
So, right, but they're saying they said to the judge that I'm not allowed to have social media, that the judge ordered that I'm not able to have social media. That is a direct lie.
Court order, oh, you're right. Will the court order denying the bond motion today reference the fact that he's not entitled per statute, per the ruling that you had indicated about violent felony offender special concern?
It's court minutes.
Okay.
I have no problem saying that the court denied the motion to set bond. But I want the record clear. I'm denying the motion to set bond because he's now been identified as a violent felony offender of special concern. I do not believe under any circumstance could I grant a bond. I don't want you to infer that I was telling you that I wanted to give him a bond, but the mean old Florida legislature won't let me do
I understand
it.
that.
My hands are tied. But
Procedurally.
rather than go down that road and even entertain argument on that point, if it can't happen, it can't happen. And
I
that's
agree.
my reading the law.
I just want to make sure that it's there because I don't I don't know what I don't know, and I'd love to find case law that says that you've got some carve out or something. I don't know. I want to do my due diligence on that.
That's fine. If you think that I'm misreading the statute,
No,
I won't be offended.
I don't-
I expect lawyers to point out, Judge, no offense.
I'm not saying you're misreading the statute. I just want to research it to see if there's a case out there that says, yeah, but, and then I can present you the yeah, but argument, and you can, accept it or reject it as you deem appropriate.
There are those cases that say shall means shall, except when it applies to a court, then it means may.
That's right.
So,
Well,
you might find that.
never know.
All right. Have a good day.
Optimism springs eternal. Thank you.
Yeah, I hear you. So all I did was tell the truth. And then he started talking crazy. He started talking about if I violated and I'm guilty of violation, he's talking about 4 to 6 years in prison.
You need to be thinking about the way that you could have made these things different. I don't care. I don't care. I don't care. I don't care. You can't start every sentence off with, no, I need you to do this thing. I don't have any more money. You getting out cost me like $10,000 for 8 weeks for you to be out? You didn't take it seriously enough. You didn't